Hello, everyone. It's an honor to be here in the Colegio de Abogados de la Ciudad de Buenos Aires. My name is Antony. I'm the president of the Comisión de Derecho a las Tecnologías Digitales. I'm going to introduce María Fernanda Mieres. María Fernanda is a partner in Beca Varela Law Firm, and she's the actual president of the whole Colegio de Abogados de la Ciudad de Buenos Aires, not just a committee as myself.
And well, my name is Adrián Palacios. I'm a senior corporate counsel for Microsoft, and I will introduce Antony Cook. Antony is a corporate vice president and deputy general counsel at Microsoft, and he leads the legal affairs organization globally.
Well, we will start with some questions we believe are interesting, we believe are important to hammer a bit. But then we will give some space to questions, doubts from the lawyers here. So far, as a president of the Bar Association, what do you see as the profession's greatest responsibility in helping lawyers navigate the AI era?
Well, first of all, thank you very much. Thank you, Antony, for being here. Thank you, Sebastian, for making it possible. We are really delighted to have you here. Actually, as we were just discussing before we started this session, is that we in the Colegio de Abogados, we are really talking a lot about AI and how this will transform our profession. So we are really honored to have you here and to have this discussion. So going back to your question, I think that the main responsibility that we have as lawyers and in my role as the chair of the Colegio de Abogados here is that I think that we have like in two different senses. On the first thing that I believe that we need to do is to provide all the lawyers with the skills that are necessary in order to incorporate the AI as a tool. We need to provide them with those skills. Actually, I believe that when most of our audience are lawyers within law firms, and I actually experienced that myself here. I have my partner which leads the legal innovation team. We are every time just providing all the legal access and the tools that the AI can, so they can use it in a daily basis. So we need to provide them all the access to train them and to provide them all those tools. And on the other side, I think that we need to, another challenge that we have here is to establish the governance frameworks to use this AI with certain responsibility. I think that those are the two things that we are navigating in the moment. On the one side, to learn how to use this AI, we need to provide our legal services using the AI as a tool, but on the other side, just learn to use it with responsibility and with transparency for our clients.
Great. And for Antony, focusing on law firms, many law firms are beginning to adopt AI tools, but this is one thing to adopt the adoption, but other thing is to become a frontier firm. A frontier firm is an organization that not only uses the AI tools, but is thinking about reinventing the way or transforming the way they operate. So, in your opinion, Antony, which will be the steps that a law firm should take to move from simply being a user of AI tools to become a true frontier firm that reinvents its operating model?
Sure. Well, thank you, and it's a real pleasure to be here. And thank you. We're also doing all this in English because my Spanish is actually really, really poor. And so you have to put up with an Australian accent, but I'll try and be as clear as I possibly can. And it's a real honour to be here. So I thanks for the invitation, and it's wonderful to be in such an amazing building. In my trip here. And I think the fascinating point that I think we're at with AI is that. And I had more hair when I started at Microsoft, but I've had the pleasure of seeing, a number of what I would think of as real transformations in technology over the course of, the last sort of 30 years. If you look at, moving first, really into the internet world, then into a mobile world, then into a cloud world, and now we're looking at an AI world. And I do think that this AI world is just fundamentally different. It is going to transform the way that lawyers work. It's going to transform the availability of information that then enables lawyers to do their work. And that's happening in-house, but it's also going to happen, within law firm practices. And I think that there are two aspects to get to really frontier. One, I think you touched upon, and I think is really, really important, and that is getting the tools into the hands of the lawyers, so that they can start to understand what the capability of the tools is and how they can use it with their work. And that needs to be done under governance frameworks and responsibly, and I think that's really important. But I think this is a technology which is so transformative that unless you have people using the technology and starting to work out how they apply it in their job, then the possibilities that the technology can release are very, very hard to understand. So, I say to my team, across Microsoft, I'm not going to find the solutions to the ways in which technology can be used to practice law differently. Because all of those, the individual lawyers are working with clients, they're working with internal clients, and they're going to be the ones that identify where the technology can be used. But they'll only do that if they know how to use the technology. So number one, I can't emphasize the point enough about skills deployment and skills enablement in law firms. That's, if you're not driving that deeply in your firms, then I think you will fall very quickly behind any notion of something that is frontier. But I think that what we've seen and what we've seen with law firms, and I spend a lot of time with in-house people, but I also spend a lot of time talking with law firms. I've been invited by a number of law firms to go and sort of review their AI plans and look at how they're thinking about AI. And the part that I think is important to recognize is that this is not just the productivity improvement tool. So it's not like a new Nexus Lexis database where, I always look at the books in libraries and most of these finish around sort of 2014, 2015. The internet sort of took over. You were no longer looking at a floppy disk to, or online to find things. You were just able to find everything online, I would say. And this is not just a technology which is going to improve productivity. It is, but it's going to change the systems in which we're all working. It's transforming businesses at a core fundamental level. And I think the most important thing for law firms to do if they're going to get to frontier is to start to look at how are they engaging with their customers? How are you operating internally? And that really means looking at what is the systems and the processes that you have in your organization. And one of the things that even in my team we did a lot of work on the productivity side, encouraging everybody to use, but we really didn't start to implement the systems for AI until we had got to the point of understanding and really starting to map how do we actually get our work done? What's the end-to-end process for how we do work? Because then you can start to look at where the technology will be applied in the most meaningful ways to transform your business. And it's also going to apply on things like, we'll touch upon, billing rates. It's going to apply in terms of what the client's expectations are. But I think if you need to start thinking about what are the systems and the workflows in your organizations, because when you apply the technology to those, that's where I think you'll start to see real frontier transformation.
Thanks. I know you're a supporter of human rights. You have a position in the IBA. Perhaps we can jump a bit into access to justice, and we can see AI as a supporter of productivity, as was said, and many other things. But what do you think about AI and access to justice? It could also become a meaningful tool for improving access to justice.
Absolutely. I think that access to justice is one of the most challenges that we have in our region, actually, specifically in Argentina. And I have seen that. I believe that AI has an enormous potential to promote this access to justice, to democratize the access to justice. But I believe that the AI will be helpful for this that I was mentioning, that there are other values that will be necessary in order to provide the poor people and the people that really need this access to justice, to promote lawyers in order to understand the fundamentals of the rights of all the legal processes, and not only to prepare simple documents, now to access to that justice. So I believe that the core values, and that's something that we in the Bar Association, through one of our committees that is called the Pro Bono Committee, we develop a lot of those values regarding the human rights in order to develop the judgment in each of the cases. So on one side, I believe that, yeah, the AI, it's a real an excellent tool, but on the other side, we need to continue developing these core values, this sort of put all the real structures and all the legal advice, and to find like this right balance between technologies and this access to justice.
Thank you. And well, my question has to do with the future of legal expertise. So for decades, legal expertise was measured by the knowledge of the lawyers, right? But now that AI tools allow or enable to surface a lot of data in just a couple of minutes, which would you say, how do you view the future of the skills that are required for a lawyer to develop, and which will be the competitive advantage that lawyers should face or should have in the future?
Sure, I might just take a moment to comment on the access to justice, because I do think the access to justice is such an important issue. I'm on the board of the World Justice Project, and we look at the implementation of rule of law globally. And part of that is really looking at how do you create the right systems for access to justice. And I think the point that you're making is so important, because the underpinning for the deployment of the technology, because at the end of the day, the technology is just the tool. And so then there has to be two, I think, sort of overall governance systems that apply into how the technology gets applied. Firstly, it's how it's built. And, this was something I think from a Microsoft perspective, at least we thought about sort of going back to sort of 2016, 2017. And I think the great thing that the company did, which I was not involved in, the company recognized that you do not want the technologists making the decision about the responsible use of the technology. And so they brought together a committee which had lawyers, it had policy people, it had humanists, it had sociologists, as well as having engineers. Because when you ultimately look at if you're going to build a technology with a responsible framework around it, you cannot just have engineers looking at it. So, I think we have applied a responsible AI policy, which is then grounded in things like fairness, transparency, accountability, reliability, trust and security, and they've been fundamental principles that are built into how we build the product. And then you have to get to, which I think is the values part of it, is then how you deploy the technology, who's going to use it, and how are they going to apply it. And I think there's still lots of work to do. And I think the work that you're thinking about in the Bar Association to describe and define the values, because ultimately those are societal differentials, right? What is important in Argentina may not be the same things that are important in other countries around the world. And I think that there's certainly from our perspective, a recognition that as you deploy the technology, you need to deploy it in the context of a value system that reflects the societal influences in the countries in which you're operating. And so I think that's something which I think is really a very important aspect of as we move into deployment. And lawyers, I think, have a particularly prominent role in that, because they're often going to be the ones that bring together the nexus of the technology, the policy, and sort of the legal framework. So I think it's a very interesting area to be prominent, and I think where lawyers can participate.
Now, yeah, I think that maybe those like easy contracts or something, when you want to know what are your rights to certain things, access to technology and to have those rights available could be a tool for the most vulnerable one. But when you have like certain cases or challenging cases, not only for the vulnerable, but also for the common people that need a little bit of judgment or or analysis. I believe that where is the work of the lawyers, that we still have something to contribute there, that not only technology can give an answer to that, no? So I think that a combination of both will be the really success, no, for the people, and to have a really access to justice.
No, I agree. And that sort of leads into, I think, when you then start to look at, because I think one of the questions that I get asked in many places is, okay, so, you know, you're working at a law firm, working at a technology firm, you're a lawyer. You know, there's lots of sort of forecasts that lawyers are all there's not going to be more lawyers. You know, AI will take over the world. AI will take over sort of the ability for legal work to be done. And, you know, I just fundamentally disagree with that, because I think it minimizes what is at the essence of legal work. And at the essence of legal work is judgment. You know, we all went and learnt how to apply in different factual contexts the rules and regulations, but all of that involved judgment. There is no such thing, or there are very few things, you know, strict liability cases is probably the exception, but there are very few things where there's a legal certainty of a factual context. And it takes somebody to be able to understand that context and interpret the context. But I do think that we all need to recognize, and I'm from the school, you know, I went to a law firm, I started in law firms, I spent hours in due diligence rooms. I spent a lot of time doing verification exercises. I did a lot of time, you know, having senior partners rip through my advices and mark them up with red pens. And, you know, so I was trained that way. That's not how we're going to train lawyers in the future. And I think what we have a journey as a profession is to identify is that we're going to train lawyers differently, because the tools that are available to lawyers are different from when we were going through our training. And so then I think the thing that we started to explore, I think that there's a lot of work to be done on this part. And it's interesting because I'm also, one of the responsibilities I have, because I lived in Singapore for a lot of years, I'm on the advisory board for one of the law schools in Singapore. And it's really interesting to look at how they're thinking about the change of the training of the profession, because we need people to have the core legal capabilities, but we also need to work out how they're going to start to use these different tools to get that ability, and to be able to do that assessment, and to be able to bring that level of judgment. Because it's not going to be in the future, can you memorize 2,000 cases and what the decisions were in those cases? That is commoditized now. You can find out that information very easily. And frankly, many lawyers are going to be able to find out that information. But what we're still going to have as a profession is the ability to understand, okay, that was the decision, but why is that decision relevant, and what weight does it carry, and how does it help me contextualize the advice that I'm giving in a particular scenario? And so I do think when I look at I talk to our internal teams, I'm not worried about headcount reductions. We'll have some headcount reductions and some headcount changes, because frankly, there was a lot of work that we were doing that was pretty boring. It was repetitious. It was low value. And where we will see lawyers move up the value curve, because actually the judgment that's going to be needed to make sense of the use of the technologies. And the fact is that you can have an agent pull all sorts of data and information for you. You're going to have agents that are going to be able to help you write briefs. You're going to have agents that are going to be able to help you write advices. But they're still going to need someone to read them to say, is this in the factual circumstances, and bearing in mind all of the other things that an AI system can't take into account because it's not living in the real world, how does that manifest itself in the advice that you're giving to a client? So I do think that the advancement of skills that we have to start to think about is, how are we looking to practice law, recognizing that the skills that we had to learn where we are today are not the things that we need moving forward. We're going to have to change those skills, which goes back to the point around, you have to start with people using the tools, because if they understand how it's starting to change the way they research, how the way they can draft, how the way they can look at using agents that can give them counter arguments to the work that they've drafted. Those are the things that still will require, and are going to continue to require, human judgment. And I think that that's just such an important thing for all of us to keep in mind. I don't think there's going to be less lawyers. but I do think that what the lawyers do and how they operate is going to be very different.
Yeah, definitely not the first time we hear that we will be out of job. Like, and actually, to me, it's very funny when the lawyers shout, "Oh, we are gonna like." To me, we are going to receive more work and funnier work. Like the amounts of cases that are incredibly fun to work. AI is bringing to the table is unmeasurable. So, but you also spoke a little bit about the lawyer for the future, and I wanted to ask to find what lawyer we need in 2030. We the Colegio has more than 100 years, and even Microsoft has been here in Argentina for more than 30 years. But here we also have a lot of young lawyers, and well, all the partners here are also working with young lawyers. So, but if a young lawyer were relating today, what skills would you encourage them to develop beyond legal knowledge to succeed in the next decade?
Wow, what a question. I wish I could have like the bowl, no, here to know the future, but listening to you, and I really agree with what you are saying, I believe that the lawyer of the future should have like 4 qualities, for me at least. And first of all, what you were saying, no, to develop this critical thinking, these judgments that you were mentioning, because as you said, AI could provide the answers, but we need somebody to analyze that and to be critical. So I think that we have a lot of challenge, no, with the new generation within our law firms and also the in-house lawyers to teach them how to develop that critical analysis when they will have like all the answers so quickly, no? So I think that's the challenge. On the other side, second, I think that they will need to build skills of communicating and to have a good relationship with the clients. No, I think that that's essential of all of the lawyers, that empathy, that the confidence that you develop with your clients. So all those skills of having the ability of communicating and being like close to the client, I believe that that's another skill that the future of the profession will need. And well, obviously to develop technological skills and to incorporate them, as you said, the earliest we adopt these tools or the new generations adopt these tools, I believe that universities need to include now in the curriculum all these kinds of technologies that I believe that at least in Argentina we are like very far away still. But I cannot imagine a lawyer not being a technological or the other way around, like being like very much involved in all technology issues. And another thing that I believe that they cannot lose is the sense of being like human and to have all those values, to not lose the identity of being a person and to not lose those values that are necessarily and all the public service that we have as lawyers. Actually, when we were talking about these pro bono commissions, and one of the commissions that within this bar association is like a very fancy one. We have like more than 5,000 lawyers all over Argentina committed in pro bono and also in-house lawyers. I believe that is when we give back to society what we have. No, I will always say that we have the key to access to justice. Nobody can access to justice if not because of us. So I believe that sense of the public service is something that every lawyer in the future should at least not lose.
Well, now maybe this is a tough one for the audience because it has to do with billable hours. Do you believe that AI will ultimately push law firms to rethink the traditional billable hours models and focus more on value-based services? And if so, what that my transition would look like? And maybe open for Maria Fernandez, a partner of law firm.
So I'll start because I do think that, it's like the lawyers are all going to be put out of business. It's the billable hour will disappear. And I do think that fundamentally, whether, many law firms are economically framed around the billable hour. That's the unit of measure in a firm. And so, over the past 10, 15 years, we've seen a lot of, fixed fee arrangements. We've seen a lot of alternative fee arrangements. And that's all. And I think that's a trend that's continuing. But that is still orientated around, ultimately the law firms go back and they look at it in the context of the unit of measure that they have, which is billable hours. That's how they remunerate people. That's how they remunerate staff. That's how they measure staff. That's how they measure people. And I do think that that's going to start to get put under pressure, because I do think that the reality for firms and your clients is they are going to be increasingly pushing to see what a value equation is. And so then the big question becomes, what is a value equation? And so then I think it's identifying what is the asset that is the key for a firm. And I would suggest, and I think this is, we sort of believe this as a company about all organizations, is that ultimately your organization, the IQ and the IP in your organization is the asset. And so that means that it's a collection of not just the advices that you provide, but it's also the way that you and the approach you take to law as firms. You compete with each other in firms, and you compete based on some firms have a particular specialty, some firms have a different approach to the law, some firms have a different approach to how they work with customers. But that intangible element is encapsulated by the communications that you have within the organization. It's that how you get to problems, solutions for customers, that the interactions between a partner and the junior solicitor and a trainee solicitor. And it's all those, there's a lot of discussion about what they call traces within an organization. And traces within an organization and the intangible ways in which your organization actually operates, but around that and the actual output of your organizations, that's the IQ, that's the brain of the collective brain of your organizations. And so then I think it's, how do you get value for that? And how are you going to distribute that to others? Because that is unique. And that is something that will continue to develop as you advise people. And so then some of that will, I think, continue probably at the top end. There will be services which really companies will come to law firms for because they don't have the expertise, they don't have the person who's really sitting at the cutting edge. And so they will pay people for that. And whether they will pay them for an hourly rate or whether they will pay them for a piece of work that's on a fixed fee rate. But I think, and we're starting to see that with some of the firms that we work with globally, the prices for that, the value for that is going to go up, because that is front end, really, really top work. Then there's going to be a bunch of work that sits down the bottom, which is common to many companies and many law firms. And then it's, how are you going to monetize that? So we are talking with a lot of companies, a lot of law firms, about how we have standard questions to lots and lots of issues that come into us from all around our business globally. That a lot of those are pretty generic sort of questions. And if I can then tap into your IQ and pay you on a consumption basis, so I pay you on a number of questions that get asked, and we have a system that works on a number of questions that gets asked, that's allowing me to take advantage of your IQ and remunerate you for it. But it's not high value work. And so you're not going to get to charge a whole bunch for it, and we're not going to pay a bunch for it, but it's going to have a threshold. And then there's going to be work that sits in the middle. And that, I think, is going to be where the interaction between law firms and their customers is going to start to move quite a lot. Because I think what we're going to see is the expectation from businesses is to say, I want to be able to integrate the way in which you're providing advice into the workflows that my company is operating. So we're starting to do that already from a commercial basis with our business. But I would say, for instance, one of the areas that we think about is HR law. Well, HR advice for us is jurisdictional. It doesn't make sense for me to have dedicated HR lawyers in a whole bunch of places around the world, because it's very jurisdictional. And I need a law firm that can do that. Then what I need from the law firm locally is I need them to be able to integrate with our HR systems and processes so that when they have a question, we don't have to go out and fill out another form and create another matter and do a brief and stuff like that. There's a workflow that says, here's all of our intelligence about this matter, about what the issues are. The law firm is working with me in terms of delivering the response to that so that I then don't use that work stream. So it comes back to like, what are the work streams that you have? What are the work streams that your business, that your clients have? And where does that sit with the overall capability and specialties that you have in an organization? So I think what we're seeing is there is a redefinition of the way in which billing models are going to work. And I think that redefinition is going to come by looking at the value that law firms create, which is the knowledge and the way that they make judgments around issues, and then how they integrate that with in different ways and how they provide value for that in different ways with the firms that they work with.
Now, just to add, I agree with what that you have said. Billable hours are being like challenged in every legal forum that we are, not only because of the AI, because of the system. Now it's being challenged right now, and we are just including in our proposals the fixed fee model or some retainer, something like that, because our clients want to have something they want to know how much of the time and how much money they will spend in lawyers. So I believe that there is being challenged. And going back to AI, maybe what we can see in another way is that I agree with you that what we will be paid for is for the value that we can add. Nevertheless, if we use AI tools or not, but the know-how that we have on a certain matter. But also I believe that if our lawyers use AI tools in order to develop a more fast answer to our clients, they will have like more time to work more. So maybe you can develop the same, maybe not the same amount of work that will take a certain workflow, as you mentioned. You will not spend time just spending time analyzing a contract or making a legal research, that all of those will be done very quickly by the AI. But then we will have some time to just look into another client, and so you will have like more time to develop and to be engaged in much more work.
Well, I would say one of the things we're starting to see with law firms is, it's still early days. So I think the benchmark for actually measuring productivity is quite difficult yet, because I don't think there's great measures for it. But I would say, internally we had a pilot. We've seen about a 30% improvement in productivity from individuals. We've been now working with law firms, and there's some Forrester studies, there's a few Gartner studies, and law firms are seeing somewhere around a 20 to 25% productivity improvement. So to your point, it just means that there's more time available to do a broader range of work or more work. And that doesn't mean that everybody has to work longer hours. It just means that there's more work that can be fitted in. And again, if you think about that, which is, and again, I've had this discussion with a lot of law firms, if you can work out a pricing model where you get paid, for the output, and you can increase the amount of output that you have, then the opportunity to actually make more money, because your people are efficient and they're able to use the technology to create more output of value for customers, then I think there's an opportunity to grow business. And to your earlier point around things like access to justice, it also opens up, one of the big constraints in access to justice is a limitation of the number of lawyers who are available to do the work. Well, if you suddenly have tools where you can double or triple the amount of pro bono cases that someone can manage, then you start to change the dynamic of where one of the constraints sits in the system. So I think the ability for people, and I must say, sometimes I think about it as like, man, I don't know that I want to do more work, but it is work that you do differently, right? So it's not more work as in longer hours, it's more work as you just do differently. You're able to get through more things, and the economic evidence is we're starting to see that's already the case.
Awesome. Well, we have seen in the last 10 years clients considering GDPR, sustainability, many aspects beyond the knowledge or the depth, the knowledge practice specifically or a branch of law. So do you envision or are you aware about companies considering how responsible the law firms are with the use of AI when picking a law firm?
It's interesting because one of the questions that is, I mean, it's kind of related to this is that the role of a I would say a general counsel and many of the legal advisors now is actually shifting quite a lot. And so, if you look at how much time they actually spend advising on law as opposed to general business strategy, but then they're licensed by bar associations, and the bar associations are licensing them to do legal work. They're not licensing them to do what may be like 75% of their job if you're an in-house lawyer, which is not related to law. So then brings in things like, well, there's start to be some cases in the UK, in Australia, there's a couple of cases in Europe where, lawyers were responsible because they were part of a board. They gave advice that was effectively not legal advice, but they were giving it in their capacity as the chief legal officer. And then they get disbarred because the advice is negligent. And so there is a big change, I think, in the scope of the roles that lawyers are being asked to provide. I do think when you start to look at what the services that are being made available for law firms, and the way in which they're using the technology, I mean, we're very clear with firms that we work with that we expect them to be using AI, but we also are clear that the human remains in the loop. And so they're responsible for making sure that they have the right systems in their organizations to, as we were talking about, to have a responsible AI framework so that the output is ultimately an output of their advice. It's not sort of an AI generated and, we used AI, therefore we don't have any liability. So, I think on straight legal issues, and then as you start to get into sort of a lot of these regulatory broader range of issues, we've tended to have some discussions different. So some organizations are holding themselves out as, we provide advisory advice in relation to sustainability or whatever. So in those contexts, we would expect them to be, if you're saying we're an expert on sustainability issues, then even if they're not strictly legal, we expect you to be responsible for those. If you're adding a broader discussion or we ask you something, look, we would like you to do a piece of research. We recently had something where we were looking at doing a piece of research around some of the cyber incidents. And one of the firms was concerned about we don't have the ability to track all this and the implication of all this. And that was, well, that's fine. We can provide a waiver in the sense of we were seeking information and we needed a broad and sort of judgment-based assessment of things. So I think that there's going to be an evolving landscape in some of these things, because I do think that the practice of law firms is expanding and the expectations of in-house is expanding as well.
I have another question that relates more to the frontier firm in the sense of collaborating, and we had a meeting with one of our customers today, and you said that one of our goals is not more emails, So in that order, and in one of your ideas that is about knowledge as a traveling asset, what would be the measures that a law firm should take in order to avoid having all the knowledge in inboxes or in silos, and how to collaborate among the members of a law firm using technology?
Sure. And I think this to me is one of the big advances that I think legal practices that both in-house and in law firms can really unlock. Because the reality is you may have 2 or 3 lawyers in your firms that are getting asked the same question by different clients. And some firms are very, very good at picking that up and understanding, this person's been asked this question, this person's been asked this question. We can research that once and then send our advice out tailored for the individual clients. There's a lot of practices where that doesn't happen. And then the other part that I think is that there's not necessarily a connection between, if we're getting asked the same question, because there's a new regulation that comes out, and so somebody wants, that you're going to have a whole bunch of clients that want to ask about a new law or a particular ruling or something like that. That's easy to identify. but it's when you've got, a range of different questions that are coming in, but they're essentially based around the same topic area. That how do you make sure that as the lawyers go and work on that, you're able to access the collective views that they've brought together. And so it's really the extension of how do you do knowledge management within your organizations, and do you use technology to maximize that knowledge management? And I think the way we've thought about it, I mean, we started, and it's not necessarily a problem that is law firms have as much, although I have seen law firms with different SharePoints and different departments for different practice groups. But when you have that and the knowledge is all dispersed around the organization, or you have very good knowledge in different parts of the organization, the reality is that you're not unlocking what I think of as the collective brain of your organization. And so you need to be able to put all the knowledge in a place where you can firstly make sure that it's in one place, because that's when you can apply AI on top of it. If you have it separated out, the AI will look at a source, or you can try and get it to sort through multiple sources. But the way that the AI will learn the best is if you have a common knowledge set up, and then you're able to really access that. And so some of the very simple things we've done is, because we had sort of 35 different SharePoints in different countries and different knowledge bases, and we aggregated into one central system that now we use is basically the knowledge hub for all of the systems that we're creating. So whether it's a client intake, whether it's our outside counsel platform, whether it's our deal platform, whether it's our intake tool, any of those things that we do are working off a common knowledge base. And so that means that we're able to just, if we do a deal in Japan, that suddenly is relevant to a deal in Germany, it doesn't have to wait until the deal's finished and everything's updated, and it's 6 months after that someone writes up a note about explaining what they did. If we've had to solve the issue, I don't have to have someone solve it again in another place. And that, we're a pretty big scale, but I think that operates at the micro level in many, many organizations. We're trying to be able to make sure that you can real time share the value of the thinking and the information and the advice and the judgment that you're applying and giving advice, and how do you create that? And email is one of the worst, and it's the company which kind of invented email, or at least popularized it through productivity. Getting out of email, because email, once it sits in people's email, you can't apply the AI in the same way over the top of that. So I think it's really important to think about the knowledge management systems and how you're really ensuring that everybody in your organization can access the information for the benefit of the firm. Because again, if you can do it once, you can do it quickly, it's a path to also making some money.
I think that you brought a key point here. I'm looking to my partner, like he's obsessed with this, like the use of the SharePoint actually, and that we share all the knowledge of the law firm, because in the end is all of the knowledge that the law firm has developed in the different areas of the advice, and it is better to have it like all concentrated in one place. But I don't know, maybe it's some of we as old lawyers, but we were used to work with our own computer, with our own samples, with my drafts of contracts. So you rely on those things that you have on your computer, and maybe you do not see now the benefits that you have to share and to use other samples of other ones, and also to know what we have answered to on a certain matter to apply it and then use it and refresh it. So, and I really believe that when we have put together, because we have experienced that, first you can provide legal advice in a more faster way than in a unique way, and with the know-how of the law firm. No, you have the identification that is something that was developed among the law firm, and I believe we are experiencing that, but I believe in the future we'll be seeing much more of that regarding then the use of the AI when you have all the things concentrated. It's an opportunity also for the training of young lawyers when they come, for instance, with a result of a research based on your own data, on your own documents. It's an opportunity of mentoring, of teaching them how to develop their critical analysis and to teach them a know-how that it is based on your own knowledge of the law firm. So I believe it's a great opportunity, and we need to change that mindset that we used to have to live like isolated lawyers, not sharing all our know-how and to realize the value that the sharing has, no? So I think that you brought a really key point.
Well, and it's interesting because in many places it's going to challenge the structure of law firms, right? Because lawyers have always been about like, I'm a smart person, I've got my knowledge, right? And so like maybe I don't want to share that because then I might not be as smart, or somebody else might get the benefit of my smart and they might do better than me. And in actual fact, you can see already that the law firms which are making the most progress, I would say globally, on leveraging their knowledge base are the English law firms. And that's largely because the compensation models that they have there are more based around equity partnerships, which are much less like the eat what you kill type of model, which is pervaded in some of the US law firms. And the US law firms, therefore, there's much less interest in sharing because actually my profits and my compensation is tied to what my team does and what my department does. It's not tied on what the firm values. And that mindset of shifting in an organization between, okay, is this a firm where the firm then benefits from all of the collective advice and that's how we advance the firm, or whether you have a fragmented compensation structure that drives then the way that knowledge is shared. So it's going to ask some interesting questions. And the thing that's interesting is I had a discussion with a US law firm not long ago that are just realizing this, and they're realizing that actually their biggest competitive disadvantage to some of the English law firms that are expanding into the US is that their knowledge sharing basis is less efficient than some of the other firms. And that's going to become, I think, an interesting competitive dynamic.
Maybe we should align our incentives, our compensation incentives in order to share all the knowledge that we have.
I see a lot of very fine legal minds here, and the idea is to open the meeting to everyone here. Ask questions. Si alguien necesita en español, la podemos traducir.
Good afternoon, and I will resort to my public. One of my main concerns is how IAs will develop, if anyway, regarding going looting. We've heard cases in which they cite case law that is non-existent, and sometimes even legislation. Would we see more of that in the future or less as they learn more about this?
I think
Thank you.
Yeah, I think there's two parts. It's a great question, and I think it's been one of the real, initial concerns that people have had. Is one, is the technology hallucinating? So is it just making stuff up? And then what are the ways that you put guardrails against that? And I think there are technology approaches that are, and I've actually, and Mike, we can share it. There's a paper we put together that I published on LinkedIn about hallucinations and the guardrails that you can put together to make sure that there are, you minimize the actual hallucinations and the technology that you're using. So there will be, I think, enhanced technical capability that will minimize some of the hallucinations. But I would say the second thing is it's a tool. And so like it's a tool that you're ultimately responsible for. And I think that's one of the things that we think is really important is that the technology remains human-centered and that there's accountability for the technology. And so, ultimately, the cases that have come before, there's a couple of the cases before the US courts where, people presented, relatively prominent law firms presented, their pleadings, and they cited cases that were made up. But that's incompetence. That's like, there should be no pleading that goes out the firm can't stand behind and that they've actually validated. And so I do think there's also how do you train people to make sure that they're not taking a shortcut of just, like whatever the AI gave me is okay, because it can look pretty good, right? And it looks pretty good, but it's like that's no replacement for judgment. And then finally, I would say one of the things that is also happening, and I think that there will be more use of this as people get more familiar with the technology, but you ultimately create a set of agents. And one of the things that you have is that you have an agent that checks your work, so you use sort of AI to check AI. Again, I would not advocate that that gets rid of the responsibility, because we were very deliberate about the choice of the word co-pilot as opposed to autopilot, because it's you're still flying the plane, and so I think that's really an important part. But I think you'll be able to use the technology as well to minimize that to ways that I think ultimately become very manageable.
Thank you.
Hello, my English is a little bit rusty, so I will try to do the question in English, but if I get stuck, I will do it in Spanish.
It's fine.
I have two main concerns with AI. One is the protection of the lawyer in the privilege of blind lawyer. I mean, when I interact with a chatbot, what are the security that I have that when I use or when I introduce information to the chatbot, I am being protected. I mean, if the company has some judicial requirement, I am going to be protected because I am interacting in the frame of being a lawyer and be protected by the privilege. And the other is that I am from a generation that was raised with the social media. Our focus has been less, more and more. We can pay attention because our attention is very, going everywhere. So
I think with
yeah. So what I am concerned about this, I use AI, of course, but how are we going to not automatize the brain, or maybe it's more a question for the senior lawyers, if they are going to be more patient with us. I mean, but maybe we can give value with other things that our raising with that technology gave us. So how is going to coexist those generations?
Well, I think it's an excellent question, and totally we have to learn about your generation, and you have a lot to provide. For instance, the use of technology, to not be afraid to using that, and I think that my generation, I am always looking at my partner that is the one in charge of the legal innovation team that always tells us as partners, come on, use the technology, we have it available, do not be afraid. When you have some matter, go through the different AI systems that we have and just check on that, and then you will have the advice like in a more proper way. So I believe that it is I don't know, we should learn from you, you should learn from us, maybe all this critical analysis to challenge what the AI is responding and not take it for good at once. So I think that it's a good combination. Now we will take the best from you of all the use of the technology to be like native on that, and maybe you will learn from us all this critical analysis, this challenging of not taking what the technology will provide us the answer or the only answer, just maybe challenging, and well, maybe we can come out with the best part of the legal advice.
So I mean, I completely agree with what you said. I do think that firms have the ability, because we face, law firms face the sort of the intergenerational issues. I think are going to be material. They're going to be you know, I have a bunch of agents. My agents are basically pretty useless because I still haven't really mastered the art of writing a good agent. So I like what I say, I just don't like the output it gives me very much. And, you know, I'm benefiting from some of my colleagues who are helping me improve what I do. But I think the other thing is that, you know, when I look at it from a sort of a leadership, management, supervisory responsibility, you know, the part that I have you know, sort of favored is how do we use the technology in a way that you're used to using it, so that you then have to validate what you're doing in ways that you have used the technology. So as an example, you know, I was given a piece of advice. And you know, I read it, I wasn't all that happy with it. And so I said, like, please go and put this into, and you know, we at Microsoft, we have the benefit of, like, you know, we can choose, like, go and use Claude, go and use ChatGPT, or not ChatGPT, but OpenAI, and go and use an open source model. I want you to do it again 3 times using different models, and then I want you to come back and tell me which one you think is the better one. So I think it involves a little bit of us understanding how you interact with the world in different ways, and then thinking about the training, because we have to train people. And just as, like, if you're going to be successful, you have to work out how you learn to have the judgment, you have to learn. And I think we've got to work out how the supervision matches the generation. So, you know, I have a son not so far away from your age, and then I also have someone who's, like, born into the whole thing. So not social media brought up. She's an 18-year-old, and that's a different set of issues. So I haven't quite figured out what to do with those as yet, apart from, like, try and just get my daughter through school. And then to your second point on privilege and confidentiality generally, I mean, I think the main point I would make there is a huge difference, and it's not necessarily well thought through, about using a commercial enterprise version of the technology and using a consumer version. Consumer version does not give you the ability to control two important things. It doesn't give you the ability to control the information that it's the overall envelope in which the technology is working. And the second thing is that there are very rarely protections in consumer products about the use of your prompts and the outputs to then be taken to train a model again. So from an enterprise perspective, and, you know, from our technology's perspective, you operate an enterprise, and you have a set of control planes that your IT administrator applies. And so you don't have access to. So from a privilege perspective, if you have access to this client's information and you are using that client's information, then you can use that, and you'll be able to use the AI in relation to that information. If you don't have access to that information, you're not authorized to have access to that information, there's a confidentiality boundary, then the technology will not give you access to that information for the use of inferencing. So you could ask a question and it would look at that information, because you can set the privacy controls at a control plane level. So there's quite a lot of technical capability now, and you can look at, there's dashboards that say who has access to what data, and those requirements are replicated in the system. The other thing is then, you know, we, in an enterprise perspective, and you know, other companies do this, but we have contractual undertakings in our agreements that say we will not use your personal data. So we won't use your prompts, and we won't use the outputs to train the models. So therefore, the idea that you may use the system, there may be a prompt or an output, and that suddenly it can pop up in some other use of the tool, is restricted, because we never have access to the purpose for it for training purposes. So they're the things I think to focus on. You know, are you using a commercial or consumer model? If you're using a commercial model, have you talked to the IT administrator about the policies that they put in place, because they have an access plane that they can do that? And then does your contract and your provider provide you with a contractual undertaking so that they're not using your information for training models? I think are the things to focus.
Antony, allow me to deep dive a little bit on the other part of the first question, because you, as Antony explained, there is like a relationship with the company, right? So terms and conditions apply, different case for consumer, for B2B. But then you mentioned like court requests, like you're asking like whether a court send you like injunction, send me all your prompts from the last week, right? So and we have seen some problematic things there. But one thing is your client. If your client was like, well, how can I avoid paying taxes in whatever country? It's your client. But regarding you as a lawyer, why I am raising my hand, because we're in a house of lawyers and we will protect this fiercely, is that there is no difference with your email, there's no difference with your whatever database, your floppy disk, if you want to use those, like that's your private information and your professional information, and it's perfectly protected. You should be responsible enough to use the enterprise version and it's part actually of and it's part of a mandatory data mapping you should do as a professional using private data from third parties, and something is probably not in the core of the formation of a university, but it should be definitely. We are still measuring how a check is measured because it's still in the university. But yes, data mapping involves those kind of things. Sorry, there's someone there.
In the context of prompt injection, when working with lots of files and information, you can very possibly find some prompt injection that can leave the tool without use and probably go without notice. What do you think this problem? Do you think of solution to it? Thank you.
So, I mean, I think the prompt injection is, I think firstly, mostly the terms of service would make that something that's not the use you're intending. So then it's a question of, is your question, well, does it become an unintentional prompt injection because you've sought to use the system? I would say the overall risk of that at the moment is, I would say, significantly declining, because the models now, the robustness and the resilience of the models, it's very hard to accidentally prompt inject. I mean, you have to have a pretty specific purpose that you're trying to go around the capability of the model. Then there's a question of why you're doing that, right? And so that's not going to be for the majority. In fact, not only for the majority, I would say for the significant majority of what the use cases are for law firms, for legal practices. It's not clear to me why you would need to go around the models for prompt injection purposes. And so to inadvertently do that is actually really quite hard now, because most of the models, certainly since the sort of the 4.0 versions of OpenAI, which are the ones we've implemented, and certainly the Claude models, the protections in the technology against sort of inadvertent accidental prompt injection are pretty robust. So you'd have to be you have a very targeted set of activities. And then it's a question of, well, what are you trying to do, right? And what's the purpose of the activity? So I think from an inadvertent perspective, I'm much less worried about that from a technology perspective.
Unless Antony it has to do with training, right? In which case, those would be IT people trying to do it in order to prove whether the system is secure enough not to allow you to prompt inject the model, right? That would be in a training context, not in a use context.
Yeah, and I would say that the training context would be, I mean, when you look at responsible AI practices, one of the responsible AI practices is how do you implement safety for models, which is really where you think about prompt injection. And as a safety concept, when you're buying the models from Microsoft or Claude or whoever, you wouldn't be testing the models. So it would really be, are you going to be doing some development in your organizations where you're going to be taking open weight models, where you're going to be taking, third-party models from, say, a Microsoft service like Foundry, where you take the model and then you're going to put it into, an application that you're developing, and therefore, from a responsible AI perspective, you would say, well, these are the things that we're going to do to make sure that the use of the third-party model has the right guardrails from a responsible AI perspective. But there's not a lot of law firms at this point, I would say, that are trying to do sort of the development of frontier models out of their own knowledge base. That may come, But then I think it comes with a different set of considerations around as you build applications in an organization, and law firms are starting to think about that, how do you then make sure you put in place a responsible AI framework? And you may do some testing on red teaming, blue teaming, green teaming we now have, to try and validate whether the model can be broken, but that's a very specific purpose. Yeah.
One last question, and then we can continue chatting with the link.
Can it be a double question for the price of one?
Just beer. We can do for the same way.
We're just looking at the drinks.
Following up of the two questions of my young colleagues over there. Maybe the last one was talking about, we recently heard in Brazil about a case which the system in Argentina is saying you upload your claim, and then the lawyer on the other side downloads it, puts it in the AI, make a good response to this. And there was an embedded prompt in the document that basically was saying to the AI of your opponent, make a lousy response. But the court detected that with certain rules. But it's interesting. And the other one, I think this about the subpoena of log reports, output logs. But not a question about if they use my data to train the model, but if a judge issues a subpoena saying, give me all the output logs of this guy, and it's connected with what you said about the interaction lawyer and company, no? Because if you are in the same network, for instance, or sharing data, it's more difficult to say, hey, here there is a attorney-client privilege involved. It's my data, it's my questions and inquiries. So, what do you think about that?
I mean, I think, there's probably one part of it which we're going to have to wait and see, because I would say at first principles, you can get to the definition that says, was this a communication between the client and attorney, and therefore is it subject to privilege? The use cases, I think we're going to end up things that are going to end up tested in court. So like, I don't think I can give a definitive opinion that, if you do these things, then there will be no, because this is a new way of, like, it's when we went back to, if you go back to the e-filings and things like that, I mean, there were all sorts of legal issues about the validity of signatures and about the validity of timing of lodgement of claims and those sorts of things, which they weren't really about the tech, they were about the way that the technology implicated the fundamental underlying principle, right? And so I think that we're going to find some issues that we don't have the complete answer to. But I think that the way that the technology is mostly being built, and I think, it's interesting your example that, there was prompt injection included in a filing was uploaded. But then I would say, but then there was a responsible AI system that worked because they identified that there was something there. So you build the right governance systems and you can start to identify, not start, you can actually make sure that when the system is implemented, that those sorts of issues are picked up. And I do think that, for confidentiality, I mean, one of the things that we do around things like competition cases. So I look at the schema of the work in which we have. Competition cases are high risk for us, right? And so when we're doing anything internal on that, we treat that differently. We risk prioritize it, but differently. We treat it differently in terms of how the data is stored, just because it's a competition issue. Now, will I need to do that in the future because I'll have better ways of doing it? I don't know, but I know that my risk profile in relation to certain data is more likely to be subject to, the sorts of issues related to privilege, confidentiality. So I'm going to put that in a slightly different bucket than I am if I've got sort of, a consumer trade complaint, because like they're low risk and there's tons of them. So I do think that part of it is as you deploy, and frankly, I think it's where lawyers have there's a good role for lawyers to play to think through how to establish principles, because the fundamental legal principles have inured, and I think they will continue they will continue. But some of the application of what they look like will morph as the technology morphs, and it's part of our job, I think, is to also interpret where there are riskier areas that you want to take different precautions in, that you might apply it differently. And I think the technology generally gives you the tools that you can make the differentiation on those things. So you can store prompts differently from different people, and for different, you can have them sorted by different categories and things like that. So you can actually use the technology to help you manage risk if you have particular areas that you're more concerned about.
Hi, thanks a lot. So regarding skills and training of lawyers, I have a question for either one of you. For example, University of Chicago Law School, recently they uploaded a document of their new guidelines. And for the first year law students, they forbade laptops, forbade cell phones, went back to their Socratic method. So I was wondering, what were you guys thinking about regarding skills? Is it soft skills? Is it the objective of better judgment? I was wondering what your thoughts were on that, regarding not so much regarding AI, but regarding first year law students. What's on your mind?
Well, I think that we have said some thought, but I reaffirm that all those like critical analysis, the judgment, the values that we were taking, this sort of, for instance, of the lawyers, this like being a service provider in the end, and like being connected with what's happening in the society. I believe that are those things that we cannot lose as lawyers. That's our key value, I believe, no? We need the technology, we need the tools. I think that the conclusion of this conference that we are now attending is that we need the technology. The technology is here to stay, and we have to learn to use it. But I believe that those tools are very necessary, because if not, we will lose what is the essence of being a lawyer, no? The critical method, the empathy, the development of the listening skills. So maybe the things to going back to the roots, as maybe you are mentioning, it is something to, again, no, the technology was something that we started thinking that was like something we needed to adopt, and that's okay. But then we realized that there are certain things that we cannot lose. And I believe that we as the city bar, we need also to focus on this through our commission, not to steal. We have something to provide to our lawyers to develop those skills, and nevertheless to say in the universities also, no?
And I would just say, I've seen the guidelines. There's a few universities that are coming out doing this, and I think I'm obviously I have my bias. I think it's slightly crazy. It's like I have 3 children. It's like I was like amazingly unsuccessful in banning them from having devices, and in banning them from playing Xbox and things like that. All it does is it deprives them of access to something which is part of actually the social ecosystem now. And I think the reality is, and we've had this discussion at the law school board that I'm on, because we're looking at curriculum evaluation. I don't think, like when I was in first year, the courses that we had to take were, it was contracts and criminal law and, torts. I think that the concept of, as a first year student, believing that you need to do 16 weeks of contracts, like in the Socratic method, I think that's dead, in my view. I think it should be like, how should you be using AI to learn the concepts? Use the tool to help you learn the knowledge, because the knowledge is going to be commoditized. Like if I've got a contract law question now, I can go and I can use Claude, I can use some other service, and I'm going to get as good an answer from a 10-year lawyer as I'm going to get from Claude, right? But the application of that as to whether it's relevant to the circumstances that I'm advising on, the business that I'm working in, the issues that are the context that's what we need people to learn. So I think, one of the things that I think we're thinking about, is to look at how do you accelerate the knowledge usage. So have people use the technology to access the knowledge, but focus on how are they applying the knowledge, how are they developing judgment, how are they using the knowledge to help them develop the capability to critically think. So, just as I've done, get answers to questions from 3 or 4 different places. Give me an evaluation of that. That will teach you is like, well, I've got to critically assess what's different between the answers that are coming between the models. I can't use AI to do that because actually the question is, why is AI different? So I think that there needs to be a real rethinking of those. And there are some law schools that are starting to go that path, and it'll be interesting to see. We'll have a difference in view. But I would be saying, first year students, go out and work out how you can use the technology to suck up the knowledge faster to get focused on the skills that are going to make the difference for how you practice law in the future.
Well, and on behalf of Microsoft, I would really like to thank you for this event, for this panel, for organizing it, Maria Fernanda, Santiago, Esteban also, and for all the colleagues. This is a very valuable for us to share perspectives between law firm lawyers and in-house lawyers in this interesting topic. So with that, we go to the
Thank you very much. Suffer someone so we can do. All right. Not sure. You've not convinced me about. Yeah,